Stephen says, we moved in about 7 years ago. Now, Stephen was renting a particular property. He says, when they moved in, no inspection check was done with the first owner. He says the new owner, so obviously the property has been sold on, the new owner has also not conducted an inspection. And this is the initial inspection when you're moving into a property, looking at, the sort of snags that are there, noting what's, the kind of damage or the condition of the property. He says, now we have moved and obviously left the property and we cleaned the house and left it as it is. But the rental agent is now deducting fees from our deposit, but there was no checklist done, which he has outlined in the beginning of his question. He says, what are my rights and what are the steps I need to use to approach the rental agent with regards to my deposit and the funds that they are now deducting from this? He says, please assist or advise. I think, clear, what information can we give to Stephen here with regard to this?
Right. Well, I think thankfully the Rental Housing Act is quite clear on the issue that when a tenant takes occupation of the property, or at least before the tenant takes occupation, a joint inspection must be held by the landlord or an agent acting on behalf of the landlord and the tenant. And this is important for the purpose of obviously recording the state of the property upon entry. And I mean, this is now a lengthy lease. 7 years is a long time, and a lot can happen in 7 years, especially given what he's saying is that the property changed owners. And so what would ideally should have happened is that an inspection should have taken place upon the commencement of the lease agreement. And that would then, practically speaking, if at the end of the lease you can then square it up and measure exactly or see exactly what damages occurred for which the tenant is liable. In this instance, that wasn't done, and neither was what I would in this instance term sort of an interim or mid-term inspection, which the new owner could have actually done at that point and said, well, this is the state of the property at this point in time in which I'm taking ownership of the property, and that was not done either. The point of this, all of this, is that unfortunately, well, fortunately for the tenant, I suppose, but the landlord has no claim against the deposits in respect of damages. That obviously excludes any rental or utilities, which could also be held back for the last month. And I would then just say, in terms of some lease agreements, there's pretty obvious things like or obligations that fall on the tenant, for instance, in where the property is carpeted, to say that the carpets should be professionally cleaned. If they're not, I think that can be fairly easy to prove, but there's no indication that this is the case here. And I would advise this tenant to approach the rental tribunal to lay a complaint and to recover the deposit which is due to him.
Thanks, Leah. Appreciate that, Stephen. I hope you've got the answers that you seek.